Donald Trump Jr.'s emails are raising legal questions about his meeting with the Russian attorney. That meeting also included the president's then campaign manager, Paul Manafort, and his current senior advisor and son-in-law, Jared Kushner. Some legal experts are pointing out that federal law makes it or declares that it is a crime for a foreigner to give money or something or some other thing of value, as it's written, in connection with a U.S. election. Federal law also states the following: no person shall knowingly solicit, accept, or receive from a foreign national any contribution or donation prohibited by the paragraphs above in this section. Paragraph B is a section that lists any other thing of value. Of course, the Russian man who set up the meeting promised very high-level, damaging information on Hillary Clinton. But the question that remains is, would that information qualify as a, quote, thing of value, unquote, under U.S. law? Donald Trump Jr. has denied any wrongdoing and said he was just seeking the usual opposition research. Elliot Felig is here. He's a former prosecutor with the Manhattan District Attorney's Office. He's going to help us through some of this. So is that a thing of value as described under federal statutes?
Potentially. I mean, the big impact, the most immediate impact is prosecutors have a lot of tools at their discretion. But to use the most powerful of those tools, like search warrants and subpoenas, you need legal authorization. So when I was a prosecutor, I couldn't just walk into court, Shep, and say, Judge, sign this warrant. Judge, sign the subpoena. I had to say to the judge, Judge, here's the valid basis, the legal basis for why I'm seeking this, and here's the criminal conduct that I think, the evidence that I think will be exposed as a result of your signing this warrant. By releasing these emails and showing this degree of welcomeness, certainly, towards receiving this information, or an awareness of Russian government interference, they've in effect emboldened or given Mueller the power potentially to walk into court and have a much broader inquiry, get search warrants and subpoenas for information he might not otherwise have been able to get. So to the extent Team Trump before was alleging Mueller's on some kind of fishing expedition, well, guess what? They just made that fishing expedition potentially a lot broader by giving him the tools to get warrants and subpoenas.
Any theories from a legal observer's perspective on why it is that Donald Trump Jr. would release these emails that the New York Times was going to publish momentarily anyway?
Right. I think he's going to say, and we've already seen a bit of this.
No, but I mean, come on.
Right.
You look at this, he got some extra stuff out there.
Right, right. But look,
thoughts on that?
He knew the Times was going to release this.
Oh, he knew it.
I don't think anyone is going to say. I don't think anyone is going to say, from a political standpoint or from a legal standpoint, that this is a win for them. Okay. At best, maybe they're getting out and saying, "Oh, look, we were being transparent." But I don't know if anyone's buying that. Transparency
is something that comes before the New York Times is about to print it. By no one's definition is this transparency.
And before a year of saying, oh, we have no idea if Russia is behind this either.
Well, okay. You can certainly make the argument this ain't a good thing. Someone sends you an email, I got stuff on Hillary, by the way, it's part of the Russian government's efforts to help your dad. But illegal. And if so, and specifically, I wonder about Jared Kushner. Mm-hmm. Most specifically.
Well, Kushner may have a separate liability because he's gotten government security clearance. So he's presumably filled out forms under penalty of perjury where if there are material omissions of fact and they were knowingly omitted, he faces culpability for that.
I know a lot of people who've taken that, who've filled that thing out. Mm-hmm. It's not like you sit down and you fill out your ACT.
Right.
There's somebody there going through every point. Now, are you sure on this? Because you can go to prison if you mess this up. Not if you lie, if you mess it up. You can potentially go to for 10 years.
Well, the challenge from the prosecutor's point is showing it was material. I think most of us would agree this is pretty material. It's relevant. It wouldn't be all over the front pages all over the world if it weren't. And the other question is, was it a knowing omission? If it was a knowing omission and it was material, then criminal liability would attach.
Well, there's a lot to go between here and there. And Bob Mueller's very...
But they've given Mueller the tools now.
He has the tools. He definitely has them. And whether people want to say it's nothing burger doesn't matter at all. It's Robert Mueller's thing now. It's great to see you. I hope you'll come back again.
Pleasure.